The text message came through at 6:47 in the morning, while I was still in my pajamas drinking coffee in a hotel room in Sedona. Don't sign anything, don't go to the meeting tomorrow, and do not tell your mother-in-law you've heard from me. I read it 3 times. The number wasn't saved in my phone. The area code was Chicago, where my late husband's family attorney had his office. I sat very still for a moment listening to the air conditioning hum, and then I did something I hadn't done in almost 4 years. I trusted my instincts instead of my grief. I booked the first flight to Portland. Let me back up, because none of this makes sense without context, and I've spent a long time learning that context is everything when someone is trying to take something from you. My husband Nathaniel died 22 months before that morning in Sedona. Pancreatic cancer, stage 4, diagnosed in March and gone by August. We had been married 11 years. We had a daughter named Ivy who was 8 years old when her father died, and we had a house in the Irvington neighborhood that we'd renovated ourselves, weekend by weekend, over the course of 3 years. We had a joint savings account, a life insurance policy, and a small investment portfolio that Nathaniel had been quietly building since before we met. What I didn't know, what nobody told me until it was almost too late, was that Nathaniel also had a trust. His grandmother had established it when he was born. A generation-skipping trust, structured so that it bypassed his parents entirely and went directly to Nathaniel, held until he turned 40. He turned 41 the year before he died, which meant the trust had transferred into his name just 12 months before his diagnosis. The trust held a little over $1.5 million in assets, real estate holdings, a brokerage account, a stake in a small commercial property in Lincoln Park. I knew nothing about this. Nathaniel never mentioned it. His family certainly never mentioned it. And when he died without updating his estate documents, because we didn't know there was anything to update, a legal gray area opened up that his mother immediately stepped into like she'd been waiting for it. My mother-in-law's name is Vera. I will be precise here because she has earned precision. Vera is a woman who has spent 68 years being underestimated by everyone who loved her, and she used that underestimation like a scalpel. She is not loud. She does not make scenes. At Nathaniel's funeral, she wore a pale gray dress and accepted condolences with a composure that I now understand was something closer to calculation. She had 2 goals after her son died. The first was to maintain access to Ivy, which I never would have denied her, because Ivy loved her grandmother and Nathaniel would have wanted that. The second goal I didn't understand until much later. She wanted the trust. Because Nathaniel died without a will that specifically addressed the trust. He had an older will from before we married that his attorney had been meaning to update. The disposition of those assets became genuinely complicated. Oregon law on intestate succession is fairly clear about a surviving spouse's rights, but a trust structured the way Nathaniel's grandmother had structured it had its own terms, its own successor trustee provisions, its own language about what happened if the primary beneficiary died before the trust was fully distributed. The successor trustee named in the original documents was Vera. She became the trustee of a $1.5 million trust 8 days after we buried her son. And I, a middle school art teacher with a mortgage and a grieving 8-year-old and no idea any of this existed, had no idea what I was sitting next to. The first year, Vera was kind. That's the part that still turns my stomach when I think about it. She brought meals. She drove Ivy to school on the days I couldn't get out of bed. She came to parent-teacher conferences. She helped me sort through Nathaniel's office, and she did it gently, and I was so broken that I held on to her kindness like it was something I deserved. She introduced me to a financial advisor named Jeffrey. She said Jeffrey had helped her with her own finances for years, that he was trustworthy, that navigating a deceased spouse's estate was complicated, and I really ought to have someone in my corner. Jeffrey wore good suits and had an office in the Pearl District and spoke in a way that made complexity sound manageable. I signed several documents in his office over the course of 6 months. He explained each one. I nodded along. I am a middle school art teacher. I can explain color theory, the history of the Impressionists, how to properly stretch a canvas. I cannot, at that point in my life, have told you the difference between a letter of instruction and a deed of assignment. Jeffrey knew this. I believe Vera knew this too. By the time the text message found me in Sedona, I had unknowingly signed documents that Jeffrey and Vera's own attorney had used to begin consolidating the trust's assets under Vera's sole administrative authority. There was a meeting scheduled for the following morning, the one the text had warned me away from, at which I was expected to sign what Jeffrey had described as a few remaining housekeeping items. The final step, he'd said, just to close everything out cleanly. What he hadn't told me was that those documents would have legally extinguished any claim Ivy and I had to Nathaniel's estate. I landed in Portland at 11:15 at night. Ivy was with my sister, which was supposed to be a Sedona weekend thing and turned into something else entirely. I drove straight home, poured a glass of water I didn't drink, and sat at my kitchen table with my laptop. I called the Chicago number back. It rang 4 times before a man picked up. He told me his name was Harlan. He said he had been Nathaniel's grandmother's estate attorney for 30 years, and that when the grandmother died, she had asked him to watch over the trust and, in her words, to make sure it ended up where she intended it to go. He had been monitoring the trust administration from a distance. He had seen the documents Jeffrey and Vera's attorney had filed with the court. He had waited, he said, because he wasn't sure how far things had gotten, but when he saw the meeting on the docket, he made the call. "You were about to sign away your daughter's inheritance," he told me. "And I don't think you knew that." I didn't say anything for a long time. "No," I finally said. "I didn't know that. Harlan told me I needed an attorney, not Jeffrey, not anyone Vera had introduced me to or recommended. My own attorney, someone whose loyalty was unambiguous. He gave me a name, a woman in Portland who specialized in trust litigation and estate disputes. He said to call her first thing in the morning and to say his name when I did. I asked him why he was doing this. He had no obligation to me. I was the wife of his former client's grandson. I was nobody to him, legally speaking. He was quiet for a moment, then he said, "Because Margaret, Nathaniel's grandmother, she told me before she died that she'd built that trust to take care of her family, not to fund a power grab. She was very specific about what she meant by family." I cried then, not delicately. The ugly kind, at my kitchen table at midnight, alone in a house that still sometimes smelled like my husband's shampoo. I called the attorney the next morning. Her name was Simone, and within 4 minutes of our first conversation I understood why Harlan had recommended her. She asked me to describe every document I had signed in the past 22 months. She asked me who had been present. She asked me whether I had received independent legal advice before signing anything. She did not seem surprised by any of my answers, which was the most frightening part. She told me to cancel the morning meeting. When I said I wasn't sure how to explain that, she said, "Tell them your schedule changed. That's all. Don't explain further." I texted Jeffrey. "My schedule has changed and I won't be able to make it today. Please reschedule." He called me twice. I let it go to voicemail. His second message was friendly, but something underneath it was tighter than usual. He said he hoped everything was okay, and that the meeting was really quite time-sensitive, and perhaps we could do it later in the week. Simone, when I played her the voicemail, made a sound that wasn't quite a laugh. "Time-sensitive for them," she said. "What came next took 7 months. I won't pretend it was clean or simple, or that I was brave throughout all of it, because I wasn't. There were days I sat in Simone's office and wondered if fighting this was worth what it was costing. Not just the legal fees, which my sister helped me cover, but the psychic weight of it. The version of Vera I had known, the woman who'd brought lasagna and driven Ivy to school, was still somewhere in my memory, and I kept bumping up against her. But Simone had pulled the documents. She had traced the paper trail. And what she found was both more calculated and more straightforward than I'd imagined, because the truly sophisticated cons usually are. Jeffrey was not an independent financial advisor. He had a referral arrangement with Vera's attorney, a man named Strickland who had been handling Vera's legal affairs for over a decade. The documents I had signed, framed as administrative and routine, were not routine. One transferred my right to petition for a trust accounting. Another waived certain spousal rights under Oregon's estate laws. A third, and this was the one Simone went very quiet about when she read it, purported to be a consent to the trust's amended distribution schedule, which had been quietly rewritten to remove Ivy as a remainder beneficiary and replace her with a charitable foundation that Vera had established and controlled. They had planned to remove my 8-year-old daughter from her father's grandmother's trust and replace her with a foundation Vera ran herself. When Simone explained this to me, I had to ask her to repeat it. Not because I hadn't heard her, but because I needed the words to land differently the second time. They didn't. "She was going to take Ivy's inheritance," I said. "That appears to have been the intent," Simone said. "And give it to herself." "Structurally, yes." I looked out the window of Simone's office at the gray Portland sky and I thought about Nathaniel. I thought about the way he used to call his mother every Sunday, without fail, even when he was exhausted, even during chemo. I thought about how much he had trusted her. I thought about his grandmother, who had built a trust to take care of her family, and how specific she had been about what she meant by family. Simone filed for an emergency order to freeze the trust assets while the dispute was litigated. The court granted it within 2 weeks, which Simone said was fast and which told her the judge had looked at the documents and seen what she saw. Vera called me the day the freeze order was served. I did not answer. She left a voicemail that was the most remarkable thing I'd heard in years. She spoke in the same gentle, composed tone she always used, and she said she was confused about what was happening, that there must have been a miscommunication, that she had always thought of me as a daughter, and she couldn't imagine how things had gotten to this point. I saved the voicemail. Simone said to save everything. Over the following months, the discovery process uncovered what Simone called a fairly comprehensive scheme. Jeffrey's referral arrangement with Strickland was documented in emails. The amended trust distribution schedule had been drafted months before Nathaniel died. Before, Simone pointed out carefully, his diagnosis was even public knowledge, which suggested that Vera had known about the trust and had begun planning even before her son's illness was terminal. I sat with that information for a long time before I let myself fully understand it. The mediation sessions were difficult. Vera arrived at each one with Strickland and a composed expression and a consistent narrative. She had only been trying to protect the family's assets. She had thought I understood what I was signing. Everything had been explained to me. Strickland was smooth and well-practiced. He made the word miscommunication do a great deal of work. Simone was not moved by this. Simone had 41 pages of documented evidence and a forensic accountant she brought to the third session, who walked through every transfer, every filing, every amendment to the trust documents, date by date, in a voice so calm and methodical that even I, watching from across the table, found it quietly devastating. Jeffrey did not appear at the mediation sessions. His attorney sent a letter. He was cooperating with investigators. He had, it turned out, done this before. Not with trusts exactly, but a similar arrangement with a different family in a different context, and there was an existing complaint with the Oregon Division of Financial Regulation. Simone used this. She used it well. The settlement came on a Tuesday in November, 7 months after I had sat at my kitchen table in the middle of the night and decided to trust a stranger's text message. Vera did not get the trust. The charitable foundation was dissolved, or rather, the trust amendment that had designated it was voided, along with the other documents I had been manipulated into signing. Ivy was restored as the remainder beneficiary. A new independent trustee was appointed by the court, not Harlan, who was retired and living in Lake Geneva, but a trust company with a fiduciary obligation and no personal relationships with anyone in the room. Vera also agreed as part of the settlement to pay a portion of my legal fees. Simone had pushed for this. She'd said it wasn't about the money, though it helped, because 7 months of trust litigation is not inexpensive, but about the record, about having documentation that what had happened was not a miscommunication. Strickland faced a state bar complaint. The last I heard, it was still under review. Jeffrey surrendered his financial advisor license as part of his agreement with regulators. Vera sent me a card at Christmas, a real card, the kind you buy at a store, with a winter landscape on the front. She wrote inside it that she hoped Ivy and I were well and that she thought about Nathaniel every day. She did not mention the trust or the settlement or any of it. I read the card once and put it in a drawer. I didn't know what else to do with it. There's no category in my mind for what she is to me now. Not quite a villain, because villains in stories are simpler than this, and not anything close to the woman I thought I knew. She is the person who tried to take my daughter's future and almost succeeded because I was too shattered by grief to read what I was signing. That's what she is. Ivy still asks about her grandmother sometimes. I tell her that people are complicated and that her grandmother loved her father very much. This is true. It is also incomplete. Someday Ivy will be old enough for the full version and I'll give it to her. But not yet. What I know now that I didn't know then. If your spouse dies, stop signing things. I don't mean this as legal advice. I mean it as the thing someone should have said to me and didn't. Grief makes you compliant. It makes you want to believe that the people handing you paperwork are doing it to help you. Some of them are. Some of them are not. Before you sign anything related to an estate, anything at all, you need an attorney whose fee you are paying yourself, someone who has never met your mother-in-law, someone who has no reason in the world to be anything other than entirely on your side. I also know that Nathaniel's grandmother built that trust the way she did on purpose. She had known Vera for 40 years. She had, I think, a realistic understanding of what her daughter-in-law was capable of. The generation skipping structure, the independent trustee provision, the choice of Harlan as the watchdog, none of it was accidental. She had built a wall around her grandchildren's future, and she had chosen someone she trusted to guard the gate. She just hadn't anticipated that her grandson would die before he turned 50, that he would leave behind a wife who didn't know any of this existed, that the wall would need to be rebuilt almost from scratch by a middle school art teacher in Portland who had to learn what a trust accounting was while simultaneously teaching 7th graders about the Baroque period. But we rebuilt it. Simone rebuilt it. Harlan, from his retirement in Lake Geneva, started it. And Ivy, who knows none of this yet, who still sleeps with the stuffed bear her father gave her the Christmas before he got sick, who draws pictures of him sometimes and leaves them on the kitchen table for me to find. Ivy's name is on those documents. Her name is there, and it is going to stay there, and nobody is ever going to quietly draft an amendment to remove it while I'm distracted by grief and misplaced trust. I won't let that happen again. I know too much now. I know what to look for. That's the thing about being pushed to the very edge of losing everything. You come back from it different. Not harder, exactly, just clearer. You learn which rooms to walk into alone, and which ones to bring a lawyer. The morning after the settlement, I picked Ivy up from school and we drove to the coast. It was November, cold and gray, and the beach was almost empty. We walked for a long time without saying much. She found a piece of sea glass, green, perfectly smooth, and put it in her jacket pocket. She said she was going to keep it forever. I told her that sounded exactly right. The ocean was the same as it always was. The wind came off the water, and Ivy leaned into me and I held on. And for the first time in almost 2 years, I let myself believe that what was ours was actually ours, that it would stay that way, and that we were going to be all right.